Ministerial Statement, Minister for Law.
Mr. Speaker, sir, members will know that Chief Justice Sek Keong retired on the 6th of November after a long and brilliant career in the law. PM sent a valedictory letter to Chief Justice Chan on the 2nd of November, and there were many other tributes to the Chief Justice from the bench, the bar, and the academia. It is my honor today to pay tribute in this House to Chief Justice Chan, one of our greatest jurists and legal minds. Our constitutional framework enshrines the rule of law and the independence of the courts and the separation of powers. The Constitution establishes the judiciary as a separate and independent institution and charges it with responsibility to interpret the law and apply the law to cases which come before it. In the discharge of its functions, the judiciary acts independently and impartially. Every person, including the government, is equal before the law. At the head of the judiciary is the Chief Justice. Through his judgments and extrajudicial writings, his appellate court hearings, and even his personal conduct, the Chief Justice sets the tone for the administration of justice in Singapore. It is a heavy responsibility, and Singapore has been singularly fortunate in that for the past 6 years, that responsibility has been discharged by Chief Justice Sek Keong. Sir, the Chief Justice came from a humble background. He lived in a communal house in Ipoh, started his education late because of the war, and he could not speak English when he went to school. But adversity did not slow him down. He was one of the top students in the senior Cambridge examinations in 1955 with 8 distinctions. He could not decide what to read in university. He was not thinking of law. He had no idea what a legal career would be like. Happily for Singapore, he was persuaded to do law by his English literature teacher, Dr. Atherton, who said he had a very crafty mind, but in a good sense. And the rest, as they say, is history. Dr. Atherton's intervention proved fateful for Singapore and our legal profession. The Chief Justice joined the inaugural LLB class in 1961 in the then University of Malaya. He was one of the top students in a class that produced several other students who went on to hold high positions in the legal field. The Chief Justice is probably unique in having to litigate for his own admission to the bar. He graduated and started serving pupillage before a University of Malaya degree was recognized, and therefore applied for abridgment of time on this ground. The chairman of the Bar Council resisted the application, arguing that the legislation required grounds, i.e. more than one ground. That technical argument was dismissed by the court, and that judgment is still in the law reports, Ray Chan Sek Keong, 1962, Malayan Law Journal, at page 88. As our new Chief Justice Menon said last week, Chief Justice Chan was correct, and that was a pattern that was to be repeated over and over again in the next 50 years. The Chief Justice practiced briefly in Kuala Lumpur before joining Bradel Brothers in Singapore in 1963. He did that because he wanted to continue to be with his then girlfriend, Elizabeth Eber, whom he subsequently married. Later, he joined Shuklin and Bock, where he rose to become the managing partner of that firm and one of Singapore's leading banking and corporate lawyers. With a complete mastery of the law and a keen understanding of commercial and practical realities, he was a counsel of choice for many banks and financial institutions. He drafted many of the standard banking and corporate documents which were used throughout Singapore in the late 70s and in the 80s. The advice he gave to clients was not only sound, but also simply and succinctly put. The lawyers in this House will know that it is more difficult to give succinct advice because you cannot hide behind verbiage. And the Chief Justice never did so. I once had advice on a guarantee that was drafted by the Chief Justice. It comprised 2 paragraphs in italics. The party which challenged the validity of the guarantee, perhaps because it was too short to be a guarantee, later backed down. Though brief, it was clear and accurate. That was the hallmark of the Chief Justice in the way he gave advice, in the way he drafted documents, and the way he wrote his judgments. His skill and expertise as a lawyer was highlighted on a broader canvas during the pan-electric collapse of 1985. At the height of the crisis, stockbrokers were unable to settle forward contracts involving Pan-L shares. That led to a domino effect, and the stockbroking system suffered a liquidity crunch. The stock exchange had to be closed for the first and only time in December 1985. During the closure, the Chief Justice was called upon to draft what are now called the lifeboat agreements, which were to extend credit by banks to insolvent stockbroking firms. There were no clear precedents, but time was of the essence. The Chief Justice did the job quickly, and he did it well. The agreements he drafted restored liquidity to the system, ensured the survival of the stock exchange, and preserved Singapore's standing as a financial center. That can be said to be the Chief Justice's finest moment as a corporate banking lawyer in Singapore. He was appointed a judicial commissioner in 1986. He was the first person to be appointed JC and later elevated to be a High Court judge in 1988. During his first judicial tenure of 6 years, between 1986 and 1992, he demonstrated the independence of mind and keenness of analysis that lawyers today are familiar with. During this period, he heard a fair number of public law cases. And in his own words, and I quote, "The decisions are fairly divided between those decided for and against the government." During this period, I started my own career in the law, and with members' indulgence, I will recount a personal anecdote. In 1987, I appeared as a Joe Grimberg in a case before the Chief Justice. The precedents were not clear. While Mr. Grimberg was making his arguments, the Chief Justice noticed in some way, I don't know how, perhaps showed in my face, that I was keen for a point to be made. Chief Justice asked Mr. Grimberg to ask me what the point was. I was quite struck that the Chief Justice noticed everything in his court. He was so alert that he even picked up on the point. In the end, in that case, the Chief Justice, despite being new on the bench, was prepared to apply his own assessment of the precedents rather than just following them, because on the facts, it was just to do so. His handling of the case, both in the way he conducted the hearing as well as his legal analysis, left a deep impression on me. Thereafter, I appeared before the Chief Justice in several other cases, and like many members of the bar, I considered it a pleasure and privilege to appear before him. He had an excellent judicial temperament, no flourish, no hyperbole, no drama. He always cut to the chase, succinct, and usually well ahead of counsel, and on top of all the issues. A first-rate, world-class judicial mind. And as Chief Justice Menon said last week, Chief Justice Chan was almost always the perfect judge to hear a case, any case. In 1992, the Chief Justice was appointed the third Attorney General of Singapore. As public prosecutor, he had the constitutional responsibility of instituting and conducting prosecutions. He acted firmly and in the public interest, and at the same time, he was fair to the accused. One example is the case of Louis Pius Gilbert in 2003, when he took the view that the High Court had exceeded its sentencing jurisdiction, and he authorized a criminal reference to the Court of Appeal to have the law clarified and the sentence that had been imposed on the accused to be reduced. As Attorney General, he defined the mission of his chambers as being, and I quote, enhance the rule of law and constitutional government in Singapore by providing sound legal advice and assistance in developing a fair and responsible legal system, furthering good public administration, and protecting the interests of the state and of the people. He enhanced the capabilities of AGC by strengthening the civil and criminal divisions and setting up the International Affairs Division and the Law Reform and Law Revision Divisions. His successors have built on this strong foundation. Today, the AGC has a full-fledged team of first-rate lawyers numbering about 250, with a breadth and depth of expertise to discharge their prosecutorial functions and to advise the government on all range of issues. The Chief Justice also contributed significantly to the reform of the law. One of his achievements relates to the reception of English law in Singapore. He had written on this topic as a young lawyer in 1961. In 1993, he persuaded the government to amend Section 5 of the Civil Law Act and enact the application of the English Law Act. The amendments ceased the automatic reception of English law, which had begun in 1826 with the Second Charter of Justice, while preserving key English enactments on commercial law. As the first law officer, the Chief Justice also personally argued 5 cases which are reported. By convention, these were the types of cases the Attorney General argued. In 2 of these cases, I was privileged to appear opposite him. All his legal qualities were fully apparent, including his fairness to his opponents in court. In addition, as his speeches show, the Chief Justice thought about a broad range of issues relating to the law, including the state of the bar and legal practice in Singapore, the social, economic, and international conditions in which the legal framework operated, and the higher values of the law and the legal profession. As Attorney General and later Chief Justice, he played a leading role in the Pedro Branca litigation. He presented our case to the International Court of Justice in a very clear manner, together with Professors Jayakumar, Professor Tomiko, and others. The court decisively upheld Singapore's sovereignty over Pedro Branca. I should mention that the Chief Justice's personal interests outside of the law, he is a keen student of history. And that helped substantially in presenting Singapore's case. His collection of Southeast Asian history books, which is one of the largest in Singapore, were used extensively during the ICJ hearing. Mr. Chan was appointed as Chief Justice in 2006. The appointment was received with great enthusiasm by the legal community. Sek Keong, the Chief Justice, was very much like Sek Keong, the man. Humble, unassuming, with a powerful intellect, and with a keen sense of integrity. Outside of the courtroom, he demanded that lawyers meet the highest standards of professional conduct, and he took decisive measures to safeguard clients' monies from errant lawyers. He constantly encouraged the legal fraternity, from senior counsel to law student, to do more pro bono work, to improve access to justice for the less fortunate amongst us. And he emphasized the need for competent advocacy in all areas of litigation. He started the Young Amicus Curiae scheme, where young lawyers could assist judges in magistrates' courts, appeals, and expose themselves to criminal work. He also stressed the need for top-tier advocacy in commercial cases. He observed that top senior counsel in Singapore were often retained by large institutions and therefore unable or unavailable to act against such institutions. And therefore, small law firms and individuals who wanted representation against large corporate banking institutions could not instruct senior counsel. He thus advocated that Queen's Counsel be allowed to appear more freely so that small law firms and individual clients can instruct them. He raised this point twice in two separate opening of legal year speeches. As a judge, the Chief Justice believed that, and I quote, "Judgments should be expressed in a language that a reasonably educated layman can understand." And indeed, his judgments stand out for their clarity, simple elegance. He believed in procedural fairness, that, quote, "Litigants must come away from the court with the feeling that even though they lost, they have had their day in court and have been heard," close quotes. He believed that the function of judges was to interpret and to apply the law, not legislate or make policy in the guise of adjudication. In that sense, he was a legal positivist. At the same time, he also believed that judges had a role in developing the law interstitially, consonant with national values and fundamental principles of the common law. To promote the practice and development of Singapore law, he issued a practice direction that Singapore cases should be cited in preference to foreign cases. In the course of his judicial career, he wrote almost 380 judgments, or more than 30 a year. His judgments, which span many areas of the law, will continue to influence our jurisprudence for many years to come. He believed in justice for the common man, and in one case, for example, he ordered the Law Society to investigate a lawyer who had engaged in what he considered to be wasteful litigation over a minor insurance claim. Above all, the Chief Justice was a firm believer in the rule of law and the duty of the court to uphold the law. In a lecture in 2010, the Chief Justice offered a rebuke to those who doubted the independence of the judiciary. So when the boy from Ipoh came to Singapore to study, settle down, start a career in the law, it was Singapore which ultimately benefited. In doing this, the Chief Justice followed in the footsteps of his two illustrious predecessors as Chief Justice. He, like them, was born and bred in Malaysia, but crossed the causeway to become a proud son and pillar of his adoptive country. In that sense, Chief Justice Menon is our first non-Malaysian Chief Justice. Sir, as the Chief Justice rose from humble beginnings to serve in all the high offices of the law as Judge, Attorney General, and Chief Justice. His tenure has strengthened the rule of law in Singapore, and he has cemented his place as one of our greatest jurists, if not the greatest. He retires with the great respect and warm affection of all who have worked with him and have appeared before him. On behalf of the government, it is my distinct privilege to thank him for his service to Singapore in the course of a long and illustrious life in the law spanning over 50 years. Thank you, sir.